around without being shady. Who knows her values, who's gone through trials. Her smiles are captured from mouth to mouth. It's not the size of her thighs she worries about, but the pride she thrives to keep that drive. That cinnamon twist, that cinnamon twist, that cinnamon twist. Ladies, can you feel me? That cinnamon twist, that cinnamon twist, that cinnamon twist. Ladies, can you hear me?
Hello. Welcome to Hanging with Your Girl Tasha. I am LaTasha Carpenter, known to the world as Your Girl Tasha, because when you hang with me, it's like you hanging with your girl, and you guys all know that that is not the way I open up my show, but this one over here just had me cracking up because she had no idea that we were going to be on live, and she's about to find out how authentic Your Girl Tasha is, okay? Because she was like, I don't know, I might be showing a little bit too much cleavage here. Anywho, guys, today is a continuation from last week, okay? Remember last week we had one of the attorneys in the studio, and we were talking about planning your estate. So we are following up today with these wonderful ladies who are representing Prince George's County as well as Charles County, and I'm going to allow them to introduce themselves to you because, as we know, they're going to help you guys. Last week we had a guest, and I loved his quote. Stephen Bennett said that we're never ready for the end of the game, okay? So today we're continuing to give you information to make sure that you are ready for the end of the game, but it's up to you to use the information. So ladies, please introduce yourself.
Hi, I am Cereta Lee, Register Wills for Prince George's County, and I've just won primary for my re-election for 4th term.
And I'm Lorraine Hennessy, Register Wills for Charles County.
And how many terms have you been?
I was elected in 2010, so I'm going on my 3rd term.
Well, thank you. And Mr. Terrence Coleman from Chicago, we appreciate you tuning in and saying hello to the ladies and sharing. That gives me a reminder. Everybody needs to share and invite. Share and invite. And remember, if you have questions, you can dial in on 301-429-9247. Again, that number is 301-429-9247. Okay, so ladies, this is so good. So people need to know, what is the function of the Register of Wills? Can y'all help educate the viewers on the function of the Register of Wills?
Sure. We oversee administration of the estate process. You know, we appoint a personal representative to be in charge of the decedent's estate.
Okay. And would you sum it up the same way, Lorraine?
I would. We do probate work, basically, for the administration of the estate.
Okay, so you guys talk about the fact that each of you have been reelected. I'd like you to share a little bit with everybody about how you acquired the position, and also what makes you approved to be subject matter experts in the position, or what did you bring to the table that made you qualified for their position. So if a Register of Wills comes open, what should people be looking for? What type of skills and, you know, all that good stuff do you need for the position?
Well, obviously, good people skills. As a registrar, you're dealing with people at a very difficult time in their lives. And so, you know, they've lost a loved one. They're grieving. So you have to be patient and caring and be able to guide them through the process. When I said earlier we do the probate work, we don't actually do the probate work. We guide you through the probate process.
I would agree with what Lorraine has just said, and you asked earlier, also from personal experience, I could speak from the heart on how important it is to have a will and to understand the process.
Okay, so what did y'all bring to the table that made you qualified to be elected for the positions?
Okay.
Or do you think made you qualified?
For me, I was an office manager of a law firm, so I was familiar with the laws of estates and trusts. I had over 30 years of insurance and real estate experience, and that's important because that's what you're dealing with in a lot of estates. People that have, you know, insurance issues, real estate issues, things of that nature. I have a long-term history from childhood of, you know, servicing the community, being out there amongst the folks, reaching out to people, being a mentor. So that helped because as the Register of Wills, You are the manager of the office, and as I was the manager of the law office, I am the manager of the Register of Wills office. And so with that, I bring all of those skills. Business savvy, knowing the ins and outs of things, dealing with your staff. Now, I certainly have a much smaller office than Prince George's County. Miss Lee has quite a bigger staff, so with a larger staff comes more issues. But so I bring a lot of things to the table.
I would add to that, I retired as a Verizon manager. Prior to being elected, I was the executive assistant to the former sheriff of the county of this county. So I bring management experience, and as Lorraine said, I have a staff of 32. And yes, that is a little different, but my management experience in prior positions is an aid to this.
Okay, now let me ask you something. Are we on last names or are we on first names? I heard you say Miss Lee. What do y'all prefer? Because I'm just your girl Tasha. So what we doing today? You prefer
First
me?
name is fine.
Cereta. All right, okay.
We said Lorraine and Cereta. That's fine.
We just gonna chill here, just talk and educate our people, okay? All right. So let's see. One of the questions that I had for those people, you know, some people already have wills, and I think they wonder. People that already have wills drawn up, do they need to come to your offices?
To register the will?
I mean, for any reason. Some people think everything is in order without going there.
Oh, no. First of all, we have a vault that's fireproof and waterproof where you can keep your will for safekeeping beforehand. So do they need to come? It's not a mandatory thing, but it's good to do. Now, once someone passes away, then that process starts. If they have a will, they bring it and we start the process.
There's no guarantee that will's going to make it from the home to our office. So that's why it's important. It's only a $5 fee to go ahead and register your will at our office. So it's there. When somebody comes in with the death certificate, then we can pull that will from safekeeping. We don't give it to anyone until we have the death certificate. Then we can give a copy to the family members if they do not have a copy already.
And that $5 is a one-time fee unless you update it, which is called a cotta. So it's a good thing to do. It's a good investment for $5.
Absolutely.
Okay, so you know, I thought about it today. I thought about putting my copy of mine in my hand and just hand it off to you today.
Not a copy. we keep the
originals.
You keep as many copies as you like.
The
we keep the original.
We want the originals.
You want the original?
Yes, ma'am.
Okay.
And most people that go to an attorney, the attorney will do 3 originals. So they will do one to give to the person whose will it is. They will usually file one in the Register of Wills office, and then they may keep one for their office, or they may give 2 to the testator.
See, that's good information to know. That is good information to know. So let me see. I'm going to have to figure out. I don't know. I know I got a whole bunch of copies, so we're going to have to see. Because I had to do mine.
Find that original.
I had to do mine over. I know I have original.
Okay.
I'm probably might be the only original, but I have several copies because I had to do it all over because I went through a divorce. Okay. So that makes me think about husbands and wives. What are y'all recommendations when it comes to a husband and wife? Is it good for them to have a joint will or to have a wills that are separate?
Separate.
It can be duplicate information, but they need separate because God forbid if something happens to them both at the same time.
Okay, all right. Okay, they was unanimous in that, guys. Did you see how they were unanimous?
We work together.
So there's a lot of people that do their own wills. They might download some information off the internet. They might decide to be like my auntie and just write it on a piece of paper after she tore up the one that the attorney did. Things like that. Does it really matter?
I would say it does not matter, but I caution people when they draft their own will, please make sure that you understand the verbiage in the will, the language of the will. It could say, in this will, I leave to my children per stirpes or per capita. Those 2 things can make a huge difference with respect to your will. So please understand the verbiage of the will if you're going to do it yourself. I always recommend people go to an attorney, have the attorney draft their will, tell the attorney what it is, how you want things to go, so that it's tailored towards your wants and needs.
Exactly.
But You do as you like.
So what was those? You said per capita and per what?
Per stirpes.
And what do both of those mean?
If you leave something per capita, and let's say you have a child that predeceases you, then that per capita, that child's heirs aren't going to receive anything in the will. So if you say, I leave to John, Tyrone, and Billy per capita, it means the last child alive is going to receive. If it's per stirpes, then again, those 3 children, their heirs and assigns will receive their share if they predecease the testator.
Okay, all right.
So again, to know the language in the will is paramount.
So I'm going to say, like I said last week, guys, if you are driving, if you're not driving, if you're at home and you got a notepad and a pen, y'all better take out your notepad and pen and write some information down here. Because I never even heard of those terms. Well, I heard of per capita. I didn't really know what it meant. But, write down the information, because this is about making sure that you guys have proper information and education. Now, it's up to you to use the education to do what you need to do. Because what are your, oh, Lord, what are your thoughts about the number of people, do I want to go there? The number of people that don't have wills.
You'd be surprised. Those persons that you think have their act together, they do not. You'd be surprised.
Yes, absolutely.
You'd really be surprised.
Oh my goodness. So look, last week I asked the attorney to share with us some of her horror stories. And I didn't even have that as a thought for a question for you, but we might that might be good for later on. We're not going to get to that right now. But y'all start thinking about some horror stories here with you. Does the will have to be in any particular type of format? Does it make a difference if it's typed or if it's handwritten or what? Does it have to be notarized? What are you looking for with it?
In Maryland, it does not have to be notarized to be legal.
You just need 2 witnesses. You have to sign it as the testator. And then you need 2 people to witness, verifying that that is your signature on that will. They don't have to read the will. They just have to know that you're saying that document is yours, and they're verifying that, in fact, you're saying that's your signature. That's all they need.
Happens?
It doesn't have to be notarized at all. A notary only counts as 1 signature. Please know that.
So how do you know that the witnesses really signed it? Because just like the kids go to school, and they supposed to have the parents sign a piece of paper to go back and say that they didn't do something. How do you know that someone didn't just take and write their information, just sign a name on there and change the handwriting up?
That's a good question. When you come to our offices and you there to open up an estate, you sign saying you're not perjuring. We're not the law, so we can't say, are you sure this is your signature? So if we find out later on, then it goes judicial, goes before the orphan court judges to determine if that's valid or not, if someone contested. So there's so many scenarios. And we don't know. If you came in today, Tasha, and you said, Mr. Johnson signed this, we don't know Mr. Johnson. Okay. But if you're signing saying that you're not perjuring, then that's a whole different story.
And more than likely, if something is not done correctly, it will eventually come out. Now, it may be coming out after death, but there will be people caveating that will or challenging that will, which will go before the orphans court. So, Now,
that's funny. A lot of people don't realize the issues that come up in this situation is dealt with orphans court, because some people don't understand. They think that the orphans court is just about orphans. Yeah. So can you give a quick synopsis of what orphans court means, or what they do there besides taking care of your the will departments, the register of wills?
We can. For example, if someone comes in today, say, Auntie passed away, I want to open the estate. You're not a relative to the deceased person. So then we would say it goes judicial. So it goes before the orphan court judges to determine if you will be appointed to be the executor of that estate, or in some cases they will appoint an attorney to be the executor. So there's so many different scenarios where the orphan court judges come in. As Lorraine said earlier, anything that's challenged, it can go before the orphan court judges.
Now, you said auntie, and I had a question about what determines if a person's kinship. If that's my auntie, I'm not a relative?
So there's a pecking order with Maryland Estates and Trust as to who has rights to letters or to serve as the personal representative of an estate. So in estates and trust, it outlines who has priority. Typically, it's a spouse and adult children. So, and then it goes beyond there. If there's no spouse and there are no adult children, and maybe there's a parent that's still alive, then they can serve as the personal representative. So there is a pecking order, and it's outlined in estates and trust who has rights to come forth and do that. If someone is alive, let's say auntie had a daughter, but daughter doesn't, they can't find her, but the niece wants to serve, then the niece can petition the court to get a judicial, what's called a judicial appointment, to serve as the personal representative of the estate.
Okay. Now, guys, let me remind, I don't think I gave this disclosure at the beginning. There's a lot of information that you're going to hear today that may make you think about your particular jurisdictions that you live in. They don't necessarily apply to your jurisdictions because there's different laws and different pecking orders everywhere. So we have a question from Deanna asking about Virginia. These ladies are not, they do not specialize in Virginia, but feel free to write down the information and then contact your local register of wills and maybe ask them how does that work within your area.
In Virginia, I'm sorry.
Go ahead.
In Virginia, you have a probate court. So you'll want to call the probate court in the county of the decedent or where the person was a resident of to get information. So our laws are statewide, so are Virginia's, so are DC's. But they're all different.
So is there not a register's will in every state or area?
Each state is different. As Lorraine said, in some states it's referred to as probate or probate court.
Oh, we
They're not
learned
all
something.
called register of wills.
Right.
Maryland is unique in saying register of wills. Other states is probate clerk or probate court. And from experience, East County in Virginia is different too.
Wow.
So you need to call the county within Virginia to find out. And for us in Maryland, we have a website that gives frequently asked questions. Other states might have that as well.
Okay, so in Prince George's County or Maryland, what is the website that they would go to for their Q&A?
Register spelled out registers.maryland, MARYLAND.gov.
G-O-V.
All right, guys, and for these particular offices, if you need to correct, the names should be popping up with their phone numbers on the screens periodically throughout the show. But if you need to contact Prince George's County, you would call
301-952-3250.
And if you need to contact Charles County, you would call
301-932-3345.
Now, I have a question from a Mr. Ed Jones chiming in. He's asking whether or not a will can be too old to serve its purpose, and what if it was filed in another state? How is that handled?
Want me to answer? If a will's it can't be too old. There's no, timeline on that. If it's filed in another state and it's filed within the laws of that state, it was executed fully in the laws of that state, we would honor it as a valid will here in the state of Maryland. So what would happen in that case if someone died in Virginia and their will was filed in Virginia, but prior to their death they became a Maryland resident? We would contact the office in Virginia, or the personal representative or whoever's looking to seek to be personal representative will contact that office and have them send it to us, not to any family member, directly to us, and then we will start the process of probate for them.
And to add to that, no will is too old. You might do a will 10 years and nothing changes, so there's no reason to say you need to update it. So no will is too old.
So, I asked the guest last week this particular question. I'd like to know your opinions. Is there a proper age to get a will?
Absolutely not. 18 years
18.
of age
18.
and older.
Oh, okay.
And some people might say, well, I don't have anything. Yes, you do. Some 18-year-olds are young entrepreneurs and they already have acquired assets. So there's no age that's too young, at least 18 years of age.
Okay, and what do you...
You might have an iTunes account, and that has value, right?
Oh, it doesn't? I don't have one. What's the value with the iTunes account?
I don't know.
I don't know.
Oh my goodness. Okay.
You know, when you think about it, some 18-year-olds already have a car.
They
Right.
do.
So if that vehicle is in their name only when they pass away, an estate has to be open to take care of that. So, you know, they do have assets.
And what is your definition of an asset? Because some people may not know that they have assets.
But Tasha, I'd say that pretty necklace and earrings you have on, that's an asset. Who would get that if something happens to you? You can say Miss Lee gets that. The vehicle you're driving, you know.
$5 paparazzi. Pop paparazzi.
Your furniture, your home, your furniture, your clothing. So many different things that you've acquired.
All right, thank
Savings
you.
accounts, bank accounts.
Yeah,
You know,
that's the records
those-
of it. People don't think
Right.
about other things when it comes to
Absolutely.
it. Because when I went to do my will, she was like, "Well, how much do you think that your estate is?" I don't know. You know, and I wouldn't even thought about taking it. But
Your
no,
jewelry?
this is a legend piece, guys. This is not the regular $5 paparazzi. I'm giving out a shout out to my paparazzi crew out there, but this is a legend piece. But yes, okay, I'll be sure that I'll put your name
You
on it.
know, ladies, thank you. Ladies have furs. You know, you have your furs, your expensive jewelry, not the Tracy Lynn's. Should I say that? You have expensive jewelry. You have your furs. You have your figurines. You know.
If you have
Oh my
homeowners or
goodness!
things
I
like that.
got some
Yeah.
figurines with the papers and all that stuff
See,
too.
so those are
Yes.
things you don't
Especially
really
in the
just leave
military.
those for anyone to have and not appreciate the way you appreciate it.
All right, Diane from Upper Marlboro, thank you for tuning in. And Sylvia, we're glad that you're enjoying the information that we're providing. So let me see. Help us understand if some people believe that when they put in their will and they direct their information to certain beneficiaries, that's the end all tell all. If that person is directed as my beneficiary, then that means that they get whatever I put in my will there. Is that true or false?
Let me clarify something. You said beneficiary. If you have a bank account or an insurance policy with the beneficiary, it's not a part of the probate process.
Okay.
So there's some people say beneficiary, but you don't really mean beneficiary.
Okay, so what do I mean?
Okay, so you can say beneficiary, but if it's something in your will you want someone to specifically have, say for example, you tell your
bequest.
daughter, I want Miss Lee to get my necklace if something happens, and if she doesn't do that, then it's like, but your mom said that. Well, then your daughter could say, well, she gave it away before she passed away. So
Okay.
there's certain things you put in your will, not specific things you want someone to have, not everything.
So if I say that I designate my house to be to my son or to my daughter, is there anything that your offices can do that can make that different than what I wish there?
Well, first off, let me ask you this. Do you own your home outright?
Do you
Most
mean, do I not
people-
have a mortgage no more and
That's
all that
correct.
stuff?
Exactly.
No,
So
ma'am.
just because it says in a will you're going to get something does not necessarily mean you get it outright.
That's
so
true.
if there's a mortgage, and let's just do a car, for instance. If there's a vehicle and it says, I give my grandson Joey my car, but you're still paying the bank for that vehicle, Joey may or may not get that vehicle. Is there money in the estate that can pay off that vehicle? Does Joey have enough money to pay the lien on that vehicle? So because it says it in the will doesn't always necessarily mean you're going to get it. We try to follow the will as closely as possible. But if the decedent has debts in the estate, maybe they died from cancer and they owe lots of doctor bills, maybe those things need to be liquidated to pay the doctor bills first, because all debts of the decedent have to be paid prior to the distribution of the estate. So that throws a monkey wrench into that thought.
Also, let me share this too, something that I'm finding out since being in office. You might have in your will you want your kids to inherit the home, but 20, 30 years later, you didn't tell the kids,
You had
and
a
they
reverse
found out you did reverse mortgage. So now your kids can't afford that home because when you got that reverse mortgage, maybe it was at $200,000. Now it's $400,000. They can't afford to pay that, nor can they afford to keep up the utilities. So you need to think about that.
Okay, cool. Diane, I'm going to get to your question, but I got something else on my mind right now. So you talking about paying off the debtors. Do they get all their money?
Not always.
Well, if it's an insolvent estate, that means...
Are they entitled to all their money, or is there like a formula that's associated with how much you have to pay off of with the money?
There's no formula. They're entitled to receive compensation for their debt. Now, they may settle for less. Maybe you have a Verizon bill out there and it hadn't been paid for months because you had cancer and nobody was paying your bills, and maybe it's $1,000. Well, the personal representative can call up Verizon and say, look, would you settle this bill for $500? And Verizon says, okay, So you can always, as a personal representative, you can always bargain, work
Negotiate.
with the, negotiate, with the debtors. So it doesn't always mean you have to pay full price for whatever they say the amount is, but most of them want the full amount of money.
So let me tell you, speaking of Verizon and things, I guess the question, do y'all have any power or authority, or even the orphans court, over if a company decides to add on a debt after the decease has happened? Case in point, when I called to turn off my mother's telephone, they told me she's in the middle of a contract and there would be an early termination fee. And I told them to go to the Gates of Heaven Cemetery, plot number, and everything at Fort Lincoln to collect it, because I wasn't paying it. Now, I didn't end up paying it because I ended up went to a supervisor, and they was like, oh, yeah, that was insensitive for her to do that. I said, you're supposed to show empathy and all this other kind of stuff. But in those type of cases, if it's something like that, you have no choice. The person is not here. They can't use the service anymore. So if people try to apply early termination fees for the cell phone, whatever it may be, how is that usually handled?
So there's a certain time frame to file a claim in the estate. If they miss that time frame, then they're out of luck. They're forever barred from filing a claim in the estate.
And what is that time frame?
Typically, it's 6 months from date of death.
Right.
Okay, in both counties.
Oh,
and throughout the
is
state.
the same for
all the laws are the same throughout the state.
Okay, so for Miss Diane, who I put on hold, her question, she said, my mom thinks that she doesn't have to do a will because I am the only child. Is that correct?
How are things titled, maybe? Would be the first question I would ask Mom. Maryland law stipulates who will receive should you pass without a will. If you go onto our website and you look at the it's the Register of Wills pamphlet, it outlines if you die without a will how things are dispersed. But again, that's how things are dispersed. How things are titled determines ownership, and I know that sounds really simple, but you really need to think about that. If Mom has a bank account and it's titled jointly with the daughter, that does not come into the estate. It goes to the joint owner. Ownership vests with the joint owner. So Mom can read this and daughter can read this, and if they're good with that, that's a personal choice they can make.
I'd like to add to that. In that situation, if she's the only daughter, if this daughter is married and God forbid if something happens to the daughter predeceases her spouse, does Mom want things to go to that son-in-law? Something for Mom to think about.
Or would you rather have it go to the grandchild?
Or a niece or nephew?
What about that, Diane?
So think about that, Mom and daughter.
What about that, Diane?
Just something to think about, because we see this all the time.
All right, so we have a Miss Cereta Evans tuning in, and she's asking, are life insurance disbursements used to liquidate debt?
Is a beneficiary on the life insurance? Is that person the beneficiary on life insurance? Depends.
The person
is that life insurance coming into the estate?
Cereta, to clarify your question, sweetheart, if you are not on public transportation, please call in on 301-429-9247, and remember to turn down your device, but call in on 301-429-9247 so you can present clarity on your question.
Yes, please.
We'll pick you up. Okay, all right now. So you talked about it would not come into the estate. What is the definition of what is an estate? What's considered as an estate?
Anything that has a beneficiary designation is not a part of the probate process. As I said earlier, a bank account, CDs, IRAs, life insurance policies. If there's a beneficiary, it's not a part of the probate process. But Cereta needs to call in and clarify her question because we need clarification on that.
So an estate is
She said her 2 children are the beneficiaries.
then
That's going to go directly to them, Cereta.
absolutely. Yeah. So an estate is whatever the decedent owned in their name alone or as tenants in common is what comes into the estate. So things jointly held do not come into the estate.
What's tenants in common?
So let's say you and I own a piece of property. You own half, I own half. It's titled. How things are titled determines ownership. It's titled tenants in common. So upon your demise, it goes to your heirs or your will, per your terms of your will. Upon my demise, it goes to my heirs or per the terms of my will. If you have things that are titled jointly, it means everybody owns as a whole.
Okay, all right, y'all get that? She said, look, she put in capital letters. Sarita is excited about that answer. She said, thank you all in capital letters. I know that's right. Okay, so y'all got to pay attention to that. Jointly owned, tenants in common, or solely the only person owning it. What's the word for that?
Sole ownership.
Sole ownership. There you go. Okay. Y'all know your girl Tasha because I don't know, just say whatever. Okay. So I think that that right now might be a good time. Oh, you know what? Someone sent me emailed me a question talking about how do you open your estates? What's the process?
You come into the office. Someone passes away. You come into the office with funeral bill, death certificate, and any paperwork that is in the deceased name only. When I say paperwork, bank account, deceased name only. Any assets owned by the deceased only, in their name only, as date of death.
Date of death, yes.
Okay.
Bank accounts, all that we need to know the balance as of date of death. But the main thing when you first come in, that's why it's good to go to the frequently asked questions. The main thing is anything deceased name only.
Okay.
So you come in with a death certificate, you come in with the documentation for the assets being the things that the people owned. Come in with all that documentation. We'll determine based on the value of that, whether it's going to be a small estate or a regular estate. There's a different process for small estates than there is for a regular estate. And then we'll guide you through the process.
And that's determined by the value of your assets.
Okay, and we have another question coming in asking, what if step siblings were left off the will for whatever reason? Are they due anything?
Good question.
That's why a will's real
That's
important.
a good question. If there's a will and stepkids were not mentioned, that person knew what they were doing. Now they can challenge it.
And I guess it doesn't matter if it's a stepkid. It could be your children. You might have left a child
That's
that you
correct.
name out.
Let me just share this with you. In some cases, parents will have their kids' name in the will and they need them $1 to disinherit. And that's their prerogative. They can do that. So, stepkids, kids, it doesn't matter. It depends on the deceased.
There is no entitlement.
No.
If your name not in that joker, you are short.
And let me just say this while we're talking about that. Maryland does not recognize common law.
Uh-oh. Talk about that thing, Cereta.
DC does. So I was in a presentation recently, and someone asked me that question. I said, well, Beyonce says put a ring on it. Miss Lee says put your name on it. DC recognizes common law. Maryland does not. So you might want to go across the line.
Put your name on it. I like that. I like that. Oh my goodness. Okay, so I'm about to act stupid. All right, let me just calm
And the reason
down.
why I say that, Natasha, because since being in office, some of the worst case scenarios is significant others. That's why I bring that up.
Even with suppose it's domestic partners as well. The same situation with domestic partners, I can imagine, right?
No.
Oh Lord!
So Maryland does have domestic partner laws.
Oh,
And that
yes,
could
they
be
do.
same sex or, heterosexual relationships. Doesn't matter. We don't have common law marriage, but we do have domestic law laws.
Wow. Okay.
And so that adds a little twist to it.
Yes.
Leave it to YGT to find the twist.
If you've been with somebody for...
Like, you don't know what to do with me.
You're bringing it up.
You've been with someone for a while and they pass away and you come into our office and say you were their, significant other, we're going to ask for documentation to prove that. Okay? And then the laws are set in the state of Maryland.
What would be
What kind of
considered as proper
documentation?
documentation for that?
They would have to have things jointly held between them.
Okay.
Maybe the home or the vehicle, and then the neighbors could say, oh, yes, they live together as
Husband and
and
wife or...
Okay. All right. That's good to know. That is good information to know. Now, somebody asked me something about purposes of a bond on an estate. I've never... What is... Why would you have a bond on an estate, and what's the purpose of it?
Okay,
security.
security. So, the bond typically covers our fees. If there's inheritance tax owed, it'll cover that. So a bond is security to make sure that, and depending upon what kind of estate, whether it's a regular or small estate, sometimes you have to bond in small estates, to make sure that the personal representative doesn't abscond with the funds in the estate. Maybe everything in the estate is
security that-
cash.
Yeah.
You need to make sure that everyone who's supposed to receive does receive, and that's why, you have bonds.
Okay.
And there are some cases where individuals take off with the money.
I know that's right. Seen some of those stories. Not going to mention any names, but okay.
Please don't.
Now look, so you guys have several times used that word personal representative. If a person is not designated, how do you determine, especially when you have siblings or one thinks that they're fighting amongst each other, you should name me this? Do you get to have a joint personal representative? Is it always one person? And if it's one person, how do you determine who to grant it to?
Good question. Now, we are saying personal representative, same as executor. Some say executor, some say personal representative. It's the same thing. You bring up the scenario of several siblings. Well, one sibling might come in today to open up an estate and is appointed. A day later, weeks or months later, another sibling might challenge that because they might say, well, she's not doing this or she did that. That's when it goes before the orphan court judges to determine if that appointed sister should remain or if they appoint another sibling. It varies. And yes, you can have a co-representative.
Okay, so if they all come in on the same day, it happens, and they are not interested in having a co-representative, and there's a debate about who should be granted it, what do you guys do?
We're going to send it to the court
Judicial.
for them to decide. So we're going to set it up for a judicial hearing for the court to decide who should be appointed as the personal representative of the estate. Now, this is assuming that the decedent died without a will. Typically, in a will, you will name the personal representative of the estate and a successor.
Okay, what other things do people have to be concerned about if they die without a will? Or what other type of things happens when a person dies without a will?
Oh my gosh, lots of things.
So many things could happen.
And this is
Even if they have a will, so many things could happen. That's a loaded question because so many different things can happen.
Okay, I think they're tongue-tied on that one a little bit. Let's go back to the chat. We have a question about how do wills differ from trusts? Is it all about taxes?
No. Doesn't matter whether you have a will or trust. With respect to inheritance tax, even if you have a trust, you're still going to pay inheritance tax. So in the state of Maryland, you have estate tax and you have inheritance tax. If you're leaving something to a direct lineal descendant of you, so you can leave to your children, your grandchildren, your brothers and sisters, your mother, father, grandparents, anybody in that direct lineal descendant of you, there is no inheritance tax.
Okay.
You leave to a friend, a cousin,
niece or nephew.
There typically is a 10% inheritance tax associated with whatever it is that's being distributed to them if it's over $1,000.
Okay.
Now the other one is the estate tax. So currently in the state of Maryland, if your estate is whatever, what are we up to now? Because it's there.
50,000.
No, 5 million. Are we up to 5 million or 3.5 million? 4. Okay. Then your estate would be subject to estate tax. For the average person, that doesn't come into play at all.
Okay, Miss Cereta says she appreciates your comments because it's good to know, because I didn't think I could name one of my children as an executor of my estate because this little thing is sticking up there. Okay, I can't see the rest of your comment because Facebook is being difficult when I'm trying to read this comment. Oh, there we go. Good to know because I didn't think I could name one of my children as an executor of my estate because they would be receiving equal shares of my estate. I thought I would have to name someone else.
Oh, no, you can name, oh, no.
So long as they're of the age of 18 to serve as the executor.
Okay.
Obviously, if they're under the age of 18, they can't serve.
Okay, do you guys have any, we talked about getting witnesses. Do you have any recommendation about how a person should select their witness, the person that signs as a witness, particularly maybe when it comes to their age? I mean, if you put your mom as your witness or your grandmother as your witness.
That's okay.
It doesn't matter, they're the witness.
No recommendation because I suppose, I mean, should you have at least one younger person because we don't know when somebody's going to pass away.
You're talking witness, not executive. No,
right,
witness
the witnesses.
Witness doesn't matter.
Well, what she's saying is you want them to be around
right.
The possibility of them living when you pass so they can
You might not want to name somebody that's 83 years old, I would think.
No, you want to think positive and think they, the witness wouldn't be challenged. You know,
the will's not going to be challenged.
So,
okay. So if the witness is dead, say both witnesses are dead on the will.
That's okay.
It's okay?
Yes.
All right. No other issues. No. So I think that this is probably a good... Oh, we got another question that came in before we go to some of your horror stories that I want you to share with people. Let's see here. How did I move that down before? Here we go. These little emojis are coming up looking crazy. What if a will has been executed, all the money has been handed out, and then it's determined that the estate owes someone money? What happens then? You guys kind of touched on that a little bit earlier, but
there's a claims period at which whoever's owed the money has to put in a claim in the estate, or can put in this claim in the estate, or notify the personal representative that they're due and owing money. If they don't do it in a timely fashion.
So in this one, it's saying if the money is already paid out.
So that means the estate's been closed. So
okay.
That means that they've gone through the process, and this person didn't file in a timely manner, so they're out of luck.
So should a person, and I think I cannot remember something with my mom. I'm the type of person, YGT don't like to let nothing wait. I want to get on it. So I remember vaguely that I immediately start paying whatever needed to be paid according to what happened when I came into the Registry of Wills. Should you wait until after that 6 months to make your payments versus paying out everything before then?
You shouldn't start that beforehand. Right.
Okay.
And the reason being, what if there wasn't enough money to pay all the claimants in the estate?
Okay.
And so Verizon got paid 100%. Pepco got paid 100%. But, Washington Gas didn't get paid because you don't have enough money now.
And is that personal representative then taking on that debt?
They may be responsible to
Depending on the
indemnify.
assets. That's why we said earlier, sometimes you have to liquidate assets to pay off the creditors.
Okay.
It depends.
Yeah.
Each estate is totally different.
Okay, well, there you go. Well, I didn't have that problem, luckily. So, time for, give me, like, both of you, like, 2 horror stories or stories that you think that really teach a lesson to some of our viewers.
Don't wait to open an estate. Don't wait 5, 6, 7, 20 years to open an estate. There's no timeline to do it. But, we have what's called heir property. So grandma owned a piece of property. She passed away. People lived there. They paid the taxes on it. They didn't worry about properly transferring grandma's property to the living heirs. 20 years passes. Grandma's children are all now deceased. Now you're on the next generation that each owns a piece of the pie. And it's a nightmare for folks. Don't put off till tomorrow what you can do today.
Okay, so give me the history behind that word of advice there without naming people. You got a situation that's in your head that's making you say that.
We get them all the time, don't we, Cereta? I had a family come in, and they're not getting along. And talking to them, their grandma had a piece of property, and she had a house on it. And grandma had 10 children, let's say. And over the years, grandma's one son that lived adjacent to that property took care of the grounds, but the people that were living in the house didn't take care of the house. The house eventually over the years became dilapidated, caved in. The son that was handling, the property, he ended up passing away. So now we're into his family. He had 8 children, and they all are fighting over his estate. Well, I'm trying to explain to them what happened to grandma's is going to happen to yours, and you still got grandma's to deal with. Do something, come to a consensus. Communication is key when going through the estate process. Talk to each other. Everybody get on board, because, you're going to end up either losing it in a tax sale, or you're going to destroy your whole family and everybody's going to be bickering. So communication, just communicate with each other. Let everybody know what's going on. Show the full picture. If you need to come and talk to your registrar, she can explain how all this works and what needs to be done. But it's incumbent upon you to do it, or hire somebody to do it for you.
And to add to what Lorraine has said, communication is the key. You can't be too secretive. You must talk to your family members. Let them know you have a will. They don't need to know what's in it, but let them know they have it. If it's registered at the registrar's office, let them know that. And one thing I found too, so many deceased have safe deposit boxes. They pass away, the family can't find the key, and guess what? They had to pay the bank for breaking open that lock. And then, within the county, one of the staff members has to go to the bank with that family member and pay the bank for breaking open that lock. So something as small as that key is crucial. That happens quite a bit. And then they think the will is in a safe deposit box. After all that, they get there and there's no will.
Yeah, I've been to many a safety deposit boxes, and it
no
gets
will.
drilled open, and there's no will. But,
Just out of curiosity, how much does something like that run?
that's $75.
Or more.
Yeah.
Yeah.
Oh, wow. Okay.
And it's a
Strange
coordination.
prices.
Yeah, it's a coordination. You have to coordinate with the bank, who has to coordinate with the locksmith, who has to coordinate with the register, so that they can all go at the same time to have that done. And we as the register have to confiscate the will if it's in the box and bring it back to our office.
Okay.
So it's not an easy thing to schedule.
And this is so important because sometimes family members are trying to finalize funeral arrangements. Then the roadblock is they can't find a key. And suppose this happens on late Friday afternoon, then our office is not open again now until Monday morning. So therefore, you're later in finalizing funeral arrangements for your loved ones. So it is so crucial to have a safe deposit box keys where someone can find it. That's why I'm saying communicate. Talk to your family members. Let them know where your important papers are, where the safe deposit box key is, and which bank.
Okay, so before we get to Cereta's horror story, we got another question coming up in here, and Lorraine might share another one, so put one in your head just in case.
We got lots of them, don't we, Cereta?
We have a question coming in, and it's kind of different, a little bit of a different spin on the one that we asked about homes. So, if I own my home, but I am still paying a mortgage and pass away leaving a will saying my daughter gets the house, as long as she continues paying the mortgage, will she be allowed to stay in the home, or will the house be sold to liquidate any debts I may have still?
That's a loaded question. Because not necessarily will she be able to continue to pay the mortgage unless she refinances as though she's starting over again, depending on the mortgage company. She might have the money and might be able to pay it, but they may not just take it from her. She needs to start over again if it's not in her name at all.
So what happens? I mean, in some cases
the
they don't.
mortgage is with the decedent, not the decedent's heirs.
But if it's, I understand it's with the decedent, what happens? Because they may not call the mortgage company and let them know that the
they don't
decedent passed.
Not right away.
So
but
if they're
sooner or
just
later.
sending in a check, if they're just sending in payments every month, then what?
Sooner or later, something will come up and they'll have to let the bank or the mortgage company know that.
Okay. All right. So the whole thing was, so it could possibly still be part of something that has to be liquidated for their debt, was the second portion of her question.
That's correct.
Yes,
So
yes, definitely.
if there's debt in the estate, that's going to need to be satisfied. So whether the home has to be sold to satisfy the debt, or another asset has to be sold, or they have to come out of pocket with some of that money to do that, you know, the dynamics of every estate's different. And as you can see, this is a very complex job as the Register of Wills. You know, we're dealing with estate issues, not to mention, you know, running an office itself, the employment of folks. So it's
pretty serious.
Yes, it is.
Pretty serious.
Yes.
So, another question that popped in my head, but I saw all these other questions, and I forget what my other question was, but Lord, I'm having an old woman moment, guys, but it's going to pop back up in here. I'm having an old woman
Not
moment.
a senior moment, an old woman.
An old woman moment, yes. Okay, I got these gray hairs up in my eyebrows, but yeah, the old one. Look, I colored them on black, so y'all thought that it was natural. Look. Someone is asking, do either of the two local governments offer some version of a do-it-yourself will on their actual websites?
No.
Isn't there a sample will on our website?
When they go on.
I think we have a very simplistic will.
Maybe a simple one.
Yeah.
As an example, not necessarily a
Correct.
guide like what you would go to Staples or what they do on the website there.
No, not anything as intricate as what you get off of Staples' website or one of the other websites. It's very simplistic.
Okay, and we have Miss Cereta Evans.
Miss Cereta's on a roll, isn't she?
She is. And look, she keep on writing these whole books that make these little emojis pop up, and I can't get these emojis off. I didn't give you an angry face. That's a slip of the finger. Yes, my grandmother has a safe deposit box, and my name and my mother's name is on it. My grandmother passed, and my mom passed 3 months later. So I am the only one who can access the box with no key. I will have to schedule a locksmith and plan a trip to West Virginia, and was told I have to pay $165 in order to have the box broken. OMG. We have Mr. Derek Terry chiming in for Charles County.
Hey, Derek.
He says, a friend of mine, father passed recently and did not change his will from the ex-wife to the new wife. Oh, shucks. So the question is, who actually has the right to the house?
Well, to the house? How's the house titled?
It sounds like, Derek, call in here. You ain't never been scared to answer the phone. 301 to call in, 301-429-9247. And we have about 7 minutes going on the show, so call in quickly to answer these questions. Miss Cereta says again, okay, thanks. I'll be meeting with the attorney Nicole. I see. I have a lot. Hold on. She was tuning in last week and this week. Thank you so much. She said, I have a lot to get in order. The broadcast has been extremely informative, and she thanks everyone.
Thank you, Cereta.
Absolutely.
Derek, 301-429-9247. Come on, hurry up real quick here. I think it might be still in the old wife's name or something, but if it's in the will and it's now titled in, okay, so
how things are titled determines ownership.
Mm-hmm.
That's going to determine whether it comes through the estate or not. So the important thing is to let us know, how is that titled? If it's titled with the ex-wife, depends. Is it jointly? Is it tenants in common? You know, there's a lot of questions.
Okay, y'all better get those things in order with your new booze. I'm going to tell you, get it in order with your new booze.
Stop procrastinating. As Miss Lee said, put your name on it.
There you go.
Make sure the ex-spouse or ex-significant other's name is not there.
And so that brings me to the thing about every year, we change the batteries in our smoke detectors. Well, now you're on a 10-year smoke detector plan. But every year you should be looking at your financial papers and making sure they're still in order with what you want. So that means reviewing your pension plans, reviewing your bank accounts, making sure, checking to see if you have beneficiaries, if who you have was on there, if that's who you still want to have. So you should always review once a year, your birthday, New Year's, whatever anniversary date you pick, to go and review all your important documents and make sure they still are what you want.
All right now.
Stop procrastinating.
That's the word of today, procrastinating.
Mm-hmm.
Now, ladies, can y'all give any advice on how to avoid going into probate? Because I'm sure it's much easier to not have to go through that process.
It's not an ugly process. Probate is not that difficult.
Can you do without it, Lorraine?
Can you do without it?
Yeah.
Again, like we said, how things are titled determines ownership.
Okay.
So, I'm not encouraging people to go out and retitle their home with a child or with someone else, but I want you to, everybody's situation's different, so you need to think how things are titled determines ownership, will determine whether it comes into an estate or not.
And anything that you can designate a beneficiary, do that, and it's not a part of the probate process.
Okay, so that's some good advice on how to avoid probate. Mr. Terry is typing back in. He just did not think to change the will. To my knowledge, it was not kept out of spite.
Okay.
Derek, we still don't know what you're talking about, but that's okay. Now we have one other question coming in right now, because I think that I'm probably about to be running down on time right here. But someone has asked, I think that we addressed this already too. Has anyone ever filed a false will, and what happens when they have filed a false will?
It goes before the orphan court judges to determine if it's valid or not.
That's that orphans court people, the orphans court people. So, ladies, with us having just a few more minutes left, is there anything that you think that we did not cover that you think that the viewers definitely need? Lorraine, I'll let you go first.
We covered a lot. Open communication while you're alive as well with your family members. I know my mother gave all us children, there were 10 of us, and gave all of us a copy of her will so that everybody understood what her intent is. Now, you don't have to go that far, but certainly whoever you name as your personal representative, please be with open communication with them. Let them know and ask them if they want to take on that responsibility. Sometimes you name a family member and they're not willing to take on that responsibility. So, talk about it. To get rid of this culture about not talking about death is a detriment to you. Talk openly about it, discuss things, and then once things pass, everybody on board has an idea of how things are going to go. There may be fights within the family, but at least you know what mom's intentions were. So that's to summarize it.
To add to that, I would say definitely open lines of communication.
One moment. Hanging with your girl Tasha, who's calling in, and where are you calling from?
Yes, hi Tasha. This is Javi from the Javi and Zenia show.
Hi.
Hi. I just had a quick comment. I know I got caught up with the Alzheimer's thing, not knowing. My father passed. My mom has Alzheimer's, and we didn't know. But we got caught up with her and my dad being on the deed of the property, and in order for us to get the house, she literally has to pass away and not go into a nursing home or something, because when she goes into a nursing home, the house has to be sold and all monies have to go to the nursing home. I'm in Maryland, Prince George's County.
So she's saying, I guess basically the home was titled jointly between husband and wife, but when Dad died, the ownership vested with Mom. Mm-hmm. So Mom was the owner of the home after Dad's death, but if Mom had to go in a nursing home, then the nursing home would probably come against the assets of the individual to help pay for the cost and care of the nursing home. Is that correct?
Right. So she has a pension that she gets every month, but they said that they would take the pension and they would come after the house. So her surviving children wouldn't have access to the house anymore. And I feel that is so wrong, because my parents worked hard for that home, for us not to get it, and the state gets it because she has Alzheimer's.
Well, it's not that the state is getting it because she has Alzheimer's, but there's a time frame on when that house could have been put in maybe a sibling's name or one of the children's names, one of your siblings' names, to avoid that. And that's,
well, see, that's just it. She's too far gone now with her Alzheimer's that she can't.
And it has to be for a certain time.
Do
right.
that.
Well, sometimes it depends on if the house is paid for, what the final bill is once Mom passes away, how much you owe Medicare or Medicaid. It's kind of strange.
So you know what I'm going to suggest? I don't know if you had the opportunity, because we're running out of time, but if you had the opportunity last week to watch your show, maybe you might want to pull up and give Nicole Slaughter as an attorney. Maybe call her and see if she has any additional advice that she can give to you that may be able to assist you.
Thank you, and thanks for taking the call.
Okay, Cereta has one more thing to say to you.
Also, if you want to call me offline in the office, that's fine. This is Cereta.
Okay. I'll get the number. Tasha, you put the number in the feed?
It's actually on the screen right now, because you're Prince George's County or Charles County?
I'm in Prince George's County.
Okay, so it's 301.
I'm home right now. I'm in my car.
Okay, it is on the screen in the lower third. Since you're here, you know what I'm talking about. Thank you, love.
Thank you, ladies.
You're welcome.
Sure.
And I'm going to take one quick minute, because I want you to share what you felt that the viewers should know. Because we're a little bit over, but hold us here. Go ahead.
Well, the one main thing is to communicate. Let your family members know that you have a will, or if you don't have a will, and start talking about these things. That's so important. And as I said earlier, anything that you can designate a beneficiary, do that, and it's not tied up in a probate process.
All right. So, ladies, I so appreciate y'all coming in here. Lorraine, I thank you. I met Lorraine at Black Girls Rock, and she made this suggestion and said that we should do this, and this was absolutely everything that I expected. I appreciate both of you being here on the show.
Thank you.
Maybe you could come back for another episode, because we might have some more things, some more questions from people. Maybe we even get you jointly with the attorney. I have everybody in here on the panel, which I really appreciate. Otherwise, guys, y'all are all welcome. I see all the thanks. I'm glad that y'all appreciate it. I'm glad we provided something for you. And I want to make sure that you guys are here next Monday to tune in for Hang With Your Girl Tasha, because we're going to be talking about the 21-day vegan challenge. Hello. Tune in. Talk to y'all later. It's your girl Tasha. Bam. Being authentically me. All right, ladies. Yes. You all right?
Yes,
around without being shady. Who knows her values? Who's gone through trials? Her smiles are captured from mouth to mouth. It's not the size of her thighs she worries about, but the pride she thrives to keep that drive. That cinnamon twist. That cinnamon twist.